Which parliament did the law for GST and luxury car tax come from? Did those laws or acts come out of the Parliament of the Commonwealth, or did it come from the Parliament of Australia, like we see on the website and currently sitting in Canberra at the moment? Because if they're coming from the Parliament of Australia, well, that'd smack quite nicely of the pretend laws that the Chief Justice was talking about.
But what happens if our courts do not serve Australians? Rather, they serve the Commonwealth registered in Washington, DC.
I thought I was part of the Commonwealth of Australia, being we the people. Next thing you know, I've come across this company called the Commonwealth of Australia that's registered with the Securities Exchange Commission in Washington.
And why is our emblem registered as a trademark with the United States Patent and Trademark Office? What about the original emblem on our Constitution, on our buildings and our courts?
So I'm presented with essentially this idea that there might be two Commonwealths. The Commonwealth being the colony, comprising of we the people, and I've got this other Commonwealth which is looking like a corporation, registered in Washington, with shareholders, an annual report that's available, a prospectus. I'm wondering if our taxes are going to shareholders or we the people, and I want to make sure that I'm paying my monies to the right people.
Not only are there two Commonwealths, there were two governments.
Government in the Constitution is called the Government of the Commonwealth, and we've got this one that turns up in our letterbox called the Australian Government, the Parliament of the Commonwealth. It's specifically defined as the Parliament of the Commonwealth, and you see the Parliament of Australia. Two different names, both parliaments in theory. Where's the evidence that the Parliament of the Commonwealth changed and became the Parliament of Australia? There must be two. One of them is defined back through the Constitution, is valid. The other one is an imposter, and you can tell that one to go away. You can treat it entirely differently.
Quote from a former Chief Justice of the High Court of Australia.
A pretended law made in excess of power is not and never has been a law at all. Anybody in the country is entitled to disregard it.
Did the Chief Justice provide us with the means to challenge the validity of law in Australia?
One, that there are pretend laws in the country. Two, that it's our job to challenge them. Three, that it's the originator's duty to demonstrate that they're legitimate.
What if today's politicians and public servants can't validate an act? Are we looking at a pretend law?
We're not quite sure whether we're dealing with two Commonwealths, and we've got the possibility that some of these acts that are being imposed upon us are not real. They're pretend laws. The telephone bill, the telephone company will send you a reminder notice. I sent Customs a reminder notice, essentially, reminding them of all the terms and conditions that would apply in the absence of their ability to demonstrate they were the same legitimate Department of Customs and Excise. So it's a reminder notice, it's an honourable thing. It gives them another 7 days to provide that evidence I was looking for.
Remember, Customs still have Scott's Corvette, and they haven't proven they are really government, and are looking more and more like a subsidiary company of the Commonwealth registered in Washington, DC, by remaining silent and thereby tacitly agreed to be in a corporate entity. A court may rule against the party if no defence is submitted within a specified period. Debt collectors issue notices of demand, and the ATO issues default assessments in the same way. The expiry of time triggers an agreed outcome by default. To invalidate the notices Scott served to Customs would require the invalidation of these same processes commonly used worldwide.
Silence in the face of evil is itself evil. God will not hold us guiltless. Not to speak is to speak. Not to act is to act.
The notice of default was to formalise the fact that no response had been received to the first two presentments, and to lay out that the terms and conditions that were now agreed upon by the parties, in this case by the absence of any objection, would apply from that point onwards.
Customs had every opportunity to prove they were not a corporate entity. As a company, they had every opportunity to reject Scott's terms and conditions. Before being invoiced, Customs made a conscious decision not to release Scott's Corvette. It was this decision, this action, that constituted further acceptance of Scott's terms. So when Customs chose to seize Scott's Corvette as surety for the payment of an unsubstantiated charge, namely GST and luxury car tax, they chose to receive an invoice in accordance with Scott's terms.
What I've done is essentially defined a period of reasonable release for my Corvette, absent evidence that Customs was the legitimate Department of Customs and Excise, and that the acts for GST and luxury car tax were valid. And beyond that date, Customs seizing my Corvette as surety for the payment of those taxes, I started counting the days. So 14 days in, after this reasonable date of release, I sent them an invoice. Gave them the final notice on the first invoice, sent them a third invoice, and gave them the opportunity to waive that one. Every opportunity, every step of the way, all I'm asking for is evidence that they're legitimate and that their acts are valid. And now they're getting themselves into this invoiced situation where I've given them every opportunity to waive the invoices, and still they're setting aside their customer service charter to respond within 5 business days, and they're sitting there stone cold silent.
After 3 notices, 3 invoices, 2 statements, and 2 overdue notices, Customs finally responded 59 days after Scott's first notice.
Until I started reading between the lines and capturing every word exactly what it meant. And that put one hell of a smile on my face as I realised exactly what was going on. And so what's happening when I look at this letter from Customs is I went looking through there for what wasn't said. Where's the information that I was demanding? Where's the evidence that says Australian Customs and Border Protection Service are actually the Department of Customs and Excise? Where's the evidence in that letter that says the Act for luxury car tax and GST was lawfully brought into existence? Rather than just quote me from the Act, where's the evidence I was looking for? They referred to the fact that laws were created within the Parliament of the Commonwealth. And I went, well, yeah, that's what it's defined within our Constitution. However, the first question that came up was, which Parliament did the law for GST and luxury car tax come from? Did those laws or acts come out of the Parliament of the Commonwealth, like I'm being told by Customs, or did it come from the Parliament of Australia, like we see on the website and currently sitting in Canberra at the moment? Which Parliament were these laws coming from? Because if they're coming from the Parliament of Australia, well, that'd smack quite nicely of the pretend laws that the Chief Justice was talking about.
Customs were factually correct in citing the Parliament of the Commonwealth of we the people, leaving Scott to presume the acts for GST and luxury car tax came from the same Parliament.
They're sitting over in the land of we can't justify our own existence. We're pointing at the legitimate system as to how laws are created and expecting me to presume that they're one and the same. And I've drawn the distinction between the two of them and asked for the evidence, and it hasn't been provided.
Was the Act for GST given royal assent by a properly commissioned Governor-General?
Your claims are baseless.
You're not listening. I didn't make a claim. I asked a question.
I don't care. It's baseless.
Customs' letter made it clear they had no intention to pay Scott's invoices. Was this express intent to breach the contract? Typically, one would turn to the courts to resolve breaches of contract. But what happens if our courts do not serve Australians? Rather, they serve the Commonwealth registered in Washington, D.C. To validate the courts in Australia, Scott turned to letters patent and instructions. issued by the late Queen Victoria in 1900.
The Governor-General may constitute and appoint in our name and on our behalf all such judges, commissioners, justices of the peace and other necessary officers and ministers of our said Commonwealth.
What if Australia didn't have a properly commissioned Governor-General, commissioned in accordance with letters patent of the late Queen Victoria? Who would give royal assent to acts? Would Australia have a lawful Commissioner for Taxation? Would Australia have a lawful Police Commissioner? How about lawfully appointed judges? Could Australians take those falsely claiming government status to a real court? Subsequent research indicated that the last lawful commission of a Governor-General for the Commonwealth comprising of we the people was in 1927. Letters patent and instructions from Queen Victoria in 1900 outlined exactly how a Governor-General must be commissioned, and they categorically reserved the power and authority to revoke those letters patent to heirs and successors of the late Queen Victoria.
So the real question is, were the recent letters patent that today's Australian government rely upon, which supposedly revoked the 1900 letters patent, issued under the Great Seal of the United Kingdom? And were those recent letters patent issued by an heir and successor to the late Queen Victoria?
Is today's Governor-General working for the Commonwealth, registered in Washington, D.C.?
Am I going to be faced with justices who report back through Canberra to Washington to that Commonwealth and not the Commonwealth comprising of we the people? And am I going to be faced with a situation where I can't take customs to court because I'm dealing with a judicial system that's owned by the same company?
In the absence of a de jure justice system, and based on Scott's maritime background, Scott served a lien against customs. Liens are used by companies worldwide. For example, shipping companies claim ownership over goods until invoices are paid. And so do customs. Scott's lien effectively mirrored the same due process courts use.
Well, the lien is essentially no more than an affidavit that lays out line by line separate points or the statements of fact of what happened. It lays out allegations and it puts the onus and responsibility onto the other party that lien is addressed to come back with evidence that would rebut each one of those points. And it's no different than in a court case. The allegations are laid and the job of the other party is to rebut those points.
The directors of Australian Customs and Border Protection Service were served the lien because directors are responsible for the actions of a company. Whereas previously it had taken 59 days for customs to respond, a letter was received almost instantly from the Director of Litigation. Customs did not rebut any point within the lien. Rather than simply address Scott's challenge, Customs chose to attack it. However, they were very careful.
And so what I was seeing here was not an actual threat, but a potential threat. We may refer this matter to the Federal Police. We may reference the Criminal Code. We may do this. And I'm having a great old laugh because it would appear that they've taken very seriously the matter that making threats without basis are going to cop them an invoice.
What if the Federal Police worked for the same Commonwealth as Customs? The company registered in Washington, D.C. Scott wrote to the federal police. They were advised determination would be made of the capacity in which they act, should they become involved. Nothing further was heard from the Australian Federal Police. 30 days into the lien against Customs, Scott still had no evidence Customs were a department of the real government. Customs wanted Scott to pay the GST and luxury car tax and then take them to court.
What didn't I get as in the way of a response from Customs? I didn't get any evidence or validation that the act that was used to substantiate or charge GST or luxury car tax was in fact lawful. I didn't get any evidence that they were the same Department of Customs and Excise as defined within our Constitution. I didn't get any evidence that those acts came from the Parliament of the Commonwealth. I didn't get this, I didn't get that, I didn't get this, I didn't get that. All the way through. Bang. Sent it back and said, here you go, have another 10 days, have another opportunity to provide me with that information demonstrating that all of this is legitimate, rebut any of my terms, all of my points that I've laid out in the affidavit, give me some evidence.
With no rebuttal to the lien by Customs, it was perfected after 90 days. By not defending against the lien, Customs had agreed to all allegations and invoices, confirming the lien as the ultimate statement of facts in the matter, just like default judgment in a court. Scott's research uncovered that Australian car owners are presently going through hell, forced to pay mechanics to degas their air conditioners to meet an unsubstantiated act, and then pay again to have it recharged. And yet Scott was exempt, seemingly by asking, "Who are you?"
A friend of mine had a package seized at Perth Airport. Customs demanded payment of GST and duty. They sent a first notice, a reminder notice, and then a final notice. At that point, we crafted a notice of our own for Customs to demonstrate they were a legitimate government department and that their acts were valid. 3 weeks later,
I got a knock on the door and my package had arrived. I thought it might have been an accident, and then I got a letter from Customs. Customs had instructed Australia Post to release my package.
Why does the same process work for Nick's package, but not Scott's Corvette? Were Customs simply incompetent or criminal?
I purchased a video projector back in March 2012 as an experiment to see if I could repeat the same success. Customs in Melbourne seized my projector and then sent me demand for GST. I sent them a demand exactly as I did for my Corvette and exactly as my friend had done. And, surprise, surprise, my projector turned up. No duty was demanded, equivalent to luxury car tax on the Corvette. They didn't even demand GST. The Department of Unlawful Air Conditioning couldn't substantiate any charges when asked, "Who are you?" Customs at Perth Airport couldn't substantiate any charges when asked, "Who are you?" And Customs in Melbourne couldn't substantiate their charges when asked, "Who are you?"
Customs in Fremantle have not been able to substantiate their charges in 12 months, yet Scott's Corvette is still held hostage.
That's ridiculous. Governments don't do that.
These frequently unanswered questions and unsubstantiated charges should throw every aspect of government in Australia under the spotlight. Stamp duty, taxation, registration, licenses, rates, every Australian is affected. Many Australians won't give a rat's. Many would prefer to pay an unsubstantiated charge than to question it. And among those who do question charges, who questions the validity of who sent it? Could this be the solution simply asking, "Who are you?" By insisting on government proving their lawful validity, imposters will stick out like dog's balls. I asked Scott, could there be any possible explanation for the appearance of two governments?
Well, I've asked the Minister for Transport, the Minister for Local Government, the Minister for Police, the Minister for Environment, and recently the Minister for Justice, and not one of them even attempted to provide me an explanation. So if we have government of the people, we've got a bunch of politicians who are totally incompetent. They can't even answer simple questions. Alternatively, our representatives arrogantly refuse to answer those who elected them. And that's the best case scenario.
Wow. If that's the best case scenario, what would be the worst?
Well, for starters, we'd have pretend laws. We'd have corporations masquerading as government, controlling our courts, police, taxation and councils, and then sending all the profits to shareholders overseas.
Personating a Commonwealth officer is a crime punishable by up to 2 years in jail.
Australians may be laid back, but we are sure quick to stand up for giving people a fair go, and we are totally committed to protecting our rights and freedoms. We are at a crossroads with the silence being experienced to very important questions. If there are legitimate answers, then Scott has exposed a level of incompetence that is a threat to our national security. Our ability to defend against people impersonating government officials has been nullified. This alone should raise the alarm. No country should be allowed to be this vulnerable to corruption and outside threats to our sovereignty. If there are no legitimate answers, then we are confronted with what could be best described as treason by stealth. Frequently unanswered questions by the Australian government cannot be tolerated any longer, and we need to unite and ensure they are held accountable. So what can you do to help? What can you do to help find the truth? Instead of driving his Corvette for the past 12 months, Scott has been the driving force behind the website truthnow.net. This website gives you the tools to ask vital questions of those claiming government status. Everything on the website is free. You can download pre-written letters to ask your representatives who they represent. And